Karen Holloway entered Daniel Mercer's locked property using a fake county permit, 3 contractors, and an excavator. By noon, she had ruptured his irrigation line and destroyed trees that had stood on his land for decades, including a black walnut planted by Daniel's father on the very day he was born. When Daniel sent her a $25,000 demand letter, Karen laughed. She stopped laughing when that simple tree dispute turned into a case worth more than $1 million. It began at 6:17 on a freezing Tuesday morning when Daniel's phone buzzed with an alert from the north gate. He opened the security feed expecting to see a deer or perhaps a delivery truck. Instead, Karen Holloway stood at the locked entrance wearing a cream-colored coat and holding a clipboard. Behind her sat a white pickup, a landscaping truck, and a trailer carrying a compact excavator. 3 contractors waited nearby while Brad Keller, the maintenance manager for Silver Pines Estates, struggled to force a key into Daniel's private lock. Daniel slowly sat up. Karen had trespassed before. During the previous 4 months, she had brought board members onto his property to inspect imaginary easements, placed survey flags inside his pasture, and even installed a sign advertising a future HOA nature trail on land the association did not own. But this was different. This time, she had brought heavy machinery. By the time Daniel dressed, pulled on his boots, and drove toward the north side of his property, the excavator had already been unloaded. Karen was directing the crew toward the trees near the pond. "Shut it down," Daniel said. Karen didn't even flinch. She pulled a document from her clipboard and handed it to him. "Emergency drainage authorization," she said. "The association has the legal right to begin work immediately." Daniel looked at the paper once and immediately knew something was wrong. The file number didn't match county formatting. The seal was outdated. The engineer listed at the bottom had retired years earlier. "Did you verify this permit yourself?" he asked. "I personally verified every part of it," Karen replied. A nearby camera captured every word. Daniel looked toward the orange flags planted deep inside his boundary. "This land isn't part of your HOA. You have no easement, no permission, and no legal right to be here. I'm formally instructing everyone present to leave. If that excavator touches my soil, every person involved will be named." The contractors hesitated. Karen stepped directly between them and Daniel. "Continue working," she ordered. "The association will assume responsibility." Daniel raised his phone and started documenting everything. The time, the vehicles, the company names, the workers, and Karen herself. "For the record," he said, keeping the phone steady, "are you personally directing this work?" "I am directing an authorized HOA project," Karen answered. Daniel lowered the phone. "All right." The excavator started. Daniel stepped backward, not because he was surrendering, but because he wanted the cameras to capture everything clearly. He knew exactly where every survey marker was positioned on that side of the property. He knew where the irrigation line ran underground. He knew which trees had been planted by his father and which sections had been carefully shaped to control runoff. Most importantly, he knew every second was becoming evidence. The first bucket tore through the soil. On the third pass, the excavator struck the irrigation line. Water exploded into the air and quickly filled the trench. "That's a pressure line," one worker shouted. The operator immediately shut down the machine. "We need to stop." Karen stared at the broken pipe. For the first time, uncertainty appeared across her face. Then she said, "Cover it." The operator looked at her in disbelief. "You can't bury a live break. The HOA hired you." Karen snapped back. "I'm directing you to continue." He climbed down from the cab. "I'm not putting my license on that." Karen immediately changed tactics. She turned toward the landscaping foreman and ordered him to clear the upper trees instead. The foreman looked uncomfortable. Daniel warned him directly. "You've been told twice now," Daniel said. "This is private property. The permit is disputed. The damage has already started. If you cut even one tree, your company will be named separately." For a moment, the warning appeared to work. Then Karen told the crew that the HOA's legal counsel had approved everything and that the association would cover any claims. It was a lie, but she delivered it with enough confidence to keep the workers moving. The chainsaws started. The first aspens came down quickly. Their roots had held the slope together for years. With the irrigation pipe still ruptured, water began carrying loose soil downhill toward the pond. The foreman noticed. "This is making the erosion worse," he said. "Then work faster," Karen replied. Then they moved toward the cedar row. Daniel felt that one personally. His father had planted those trees after Daniel's mother died. Henry Mercer had never officially called them a memorial, but everyone in the family knew exactly what they represented. One after another, the cedars crashed to the ground. Then Daniel noticed a small metal sign fall into the mud from one of the nearby trunks. He picked it up and wiped it clean with his thumb. The engraved words were still visible. "Plant something you will never live long enough to sit beneath." Daniel slowly turned and looked at the crew. They were positioning themselves beside the largest black walnut near the pond, the very tree Daniel's father had planted on the day Daniel was born. "That tree is more than 45 years old," Daniel said firmly. "Do not touch it." Karen stepped forward. "It's inside the approved corridor." Daniel stared at her. "There is no approved corridor." Karen pointed toward the fake boundary flags. Daniel shook his head. "You know those aren't the actual property line." Karen's voice became colder. "Remove the tree." The foreman immediately asked her to put that order in writing. Karen signed it without hesitation and handed the document to him. Daniel raised his phone again. "For the record, Karen Holloway is personally ordering the removal of this walnut tree, even after being informed that it stands on private property." The chainsaw then bit into the massive trunk. The hardwood resisted. The engine dropped into a deep, grinding roar. Slowly, the walnut began to lean. Seconds later, it crashed beside the pond. Even Karen appeared shocked by how massive the tree was. Daniel walked over to the fallen trunk and placed his hand against the exposed wood. The growth rings were tight and deeply layered, marking decades of winters, droughts, storms, and careful growth. All of it had disappeared in a matter of minutes. Karen looked across the destroyed slope and said, "You were warned this would happen if you continued obstructing the project." Before Daniel could respond, a sheriff's SUV came through the north gate. Deputy Aaron Mills looked at the excavator, the ruptured irrigation line, and the fallen trees, then immediately ordered everyone to stop. Karen approached him and quickly handed over the permit. "This is an authorized emergency drainage project," she said. "Mr. Mercer is interfering with work designed to protect the community." Mills examined the document, then looked toward the muddy trench and the original survey marker still clearly visible in the grass far behind the equipment. "Who issued this?" he asked. "The county engineering department," Karen replied. "And who owns this land?" Karen pointed toward the orange flags. "The association has access through a shared corridor." "There is no shared corridor," Daniel said. "The deed, county maps, and survey all confirm that." Mills ordered the contractors to remove their equipment and leave until the property records and permit could be verified. He photographed the broken irrigation pipe, the tree stumps, the fallen trees, and the document Karen had presented. By noon, the entire crew had left. But Daniel's property was hardly peaceful. Mud covered the damaged slope. The broken line continued leaking water. Fresh stumps remained where shade and privacy had stood only hours earlier. That afternoon, Daniel began preserving every piece of evidence. He photographed each stump, measured the distance from the excavation to the original survey marker, collected pieces of the damaged pipe, and stored copies of all security footage in several different locations. The following morning, Surveyor Miguel Santos arrived carrying GPS equipment and official county records. By early afternoon, he called Daniel over to the boundary line. "This is worse than I expected," Miguel said. Karen's orange flags had been planted between 56 and 62 feet inside Daniel's property. But the more serious discovery was still ahead. 2 original boundary markers had been removed and replaced with newer rods almost 38 feet farther onto Daniel's land. "These weren't misplaced," Miguel said. "Someone deliberately moved them." Daniel already had an idea who was responsible. That evening, he reviewed weeks of security footage and finally found the answer. 12 nights before the excavation, an HOA maintenance truck had stopped near the northern boundary. Brad Keller stepped out carrying a metal detector and shovel. Karen stood beside him holding a flashlight. The footage showed Brad locating an original iron marker, digging it from the ground, and installing a replacement rod deeper inside Daniel's property. Then Karen's voice could be heard clearly. Once the new markers are in, no one will remember the old line. Daniel immediately sent the footage to his attorney, Rachel Bennett. Rachel arrived the next day and carefully reviewed the video, Miguel's preliminary survey, Karen's signed trespass acknowledgement, and the sheriff's report. Then she looked at Daniel and said, "We don't begin with outrage. We begin with numbers." The first demand was deliberately conservative. Emergency surveying, irrigation repairs, temporary erosion control, slope stabilization, evidence preservation, and legal preparation brought the immediate documented losses to exactly $25,000. Rachel assembled everything into a thick demand binder and gave Karen 10 business days to either pay the amount or begin negotiations. The letter was then delivered. The letter also warned that the value of the destroyed trees had not yet been included. A process server delivered it Friday morning. Karen opened the document inside the HOA office, laughed at the amount, called the trees worthless, and ripped the first page in half. One board member immediately looked uncomfortable, but Karen ignored him. She announced that she would call an emergency HOA meeting and ask the community to support a countersuit against Daniel. By that afternoon, Daniel had a photograph of the torn letter sitting inside Karen's trash can. When Rachel saw the picture, she asked only one question. "Has a certified arborist inspected the property yet?" Daniel admitted he had not. "Then don't send another letter," Rachel said. Karen may have just laughed at the cheapest offer she was ever going to receive. On Monday morning, consulting arborist Dr. Samuel Reed arrived. He spent hours measuring the stumps, examining the root damage, checking soil conditions, and reviewing old family photographs Daniel had found in albums and storage boxes. One photograph showed Henry Mercer standing beside the walnut when it was still a tiny sapling. Another showed Daniel as a boy near the pond, with the same tree already growing wide and tall behind him. Samuel explained that mature trees were not valued simply as raw timber. Species, age, canopy size, health, privacy benefits, erosion control, environmental function, and the difficulty of replacing the tree all mattered. "You can plant another walnut tomorrow," Samuel told Daniel. "You cannot by 46 years. By the end of his inspection, the numbers were staggering. The 7 black walnuts represented the largest portion of the value, followed by the red oaks, cedars, and aspens. The damaged irrigation line, exposed roots, destabilized slope, altered drainage pattern, and loss of privacy pushed the restoration costs even higher. Samuel provided a conservative valuation range for the trees alone, $286,000 to $410,000. Land restoration and long-term maintenance would add significantly more. Then Rachel and Samuel discovered another problem. Several of the most valuable walnut and oak trunks were missing. They had not been left at the property, and nobody had documented them as waste. Daniel immediately reviewed the security footage again. Hours after the sheriff ordered everyone to stop, an unmarked flatbed truck entered through the north gate. Brad Keller drove ahead of it. 2 men used a hydraulic loader to remove the best walnut and red oak sections while Karen stood nearby, pointing out which logs they should take. Rachel traced the truck to Front Range Specialty Lumber. The broker admitted that he had purchased the hardwood for just under $18,000 from a woman claiming to represent a community project. He provided the invoice. The seller was listed as Holloway Community Consulting LLC, not the HOA. The company belonged to Karen's younger brother. Rachel immediately checked the state business registry. The connection was obvious. Same family, same money trail, same project. She looked at Daniel and said, "This changes the case." Karen had not simply destroyed the trees. She had profited from them. She publicly called the trees worthless while arranging a private sale through her brother's company on the very day they were cut. That made an accident defense much harder to believe and created a direct financial trail. The case now expanded to include Karen personally, the HOA, Brad Keller, the landscaping company, the excavation contractor, the survey subcontractor, HOA Community Consulting, and anyone else who had entered the property, approved the work, cut the trees, moved the logs, or sold the timber. Meanwhile, Karen began pushing her own version of events. She emailed every homeowner in Silver Pines, accusing Daniel of trying to extort the association and describing the trespass as nothing more than a routine drainage project. She claimed the boundary had always been disputed, insisted the work was necessary to protect the neighborhood from flooding, and demanded that residents attend an emergency community meeting. She expected frightened homeowners. She expected their support. What she didn't expect was Daniel arriving with Rachel Bennett, Miguel Santos, and the evidence. By 6:45 Friday evening, the Silver Pines clubhouse was packed. Karen stood at the front of the room wearing a navy suit, projecting confidence while presenting her proposed nature walk. On the map behind her, Daniel's private pond was labeled as an HOA reflection pond, while a strip of his property was marked as a shared environmental corridor. The phrase had no legal meaning, but it sounded official enough to mislead homeowners who didn't know the facts. Karen called Daniel's demand excessive and asked residents to approve a $500 emergency legal assessment from every household, so the association could defend itself and continue the project. That was the moment the room began to change. People who had arrived prepared to blame Daniel suddenly realized the dispute could cost them hundreds of dollars personally. Then the doors opened. Daniel walked in with Rachel and Miguel. Karen immediately objected, but Rachel calmly told the room that Daniel was there to correct false statements being used to collect money over his property. Daniel stepped forward and asked only 3 questions. First, did Karen still maintain that the county permit was genuine? She said yes. Second, did she still maintain that the replacement survey markers were legitimate? Karen avoided the question at first, then insisted that the replacement markers were valid. Rachel moved forward. The first witness appeared by video, a county official who confirmed that the permit was completely fake. The file number did not exist. The seal had been retired, and the signature belonged to an engineer who had left county employment years earlier. Then Miguel presented the survey overlay. The original markers, deed, GPS measurements, and historical records all matched perfectly. The replacement rods did not. They had been installed deep inside Daniel's property. Karen called the evidence speculation. Rachel responded by playing the nighttime security footage. Everyone in the clubhouse watched Brad digging up an original boundary marker while Karen stood beside him holding a flashlight. Then her recorded voice filled the room. Once the new markers are in, no one will remember the old line. The clubhouse went completely silent. Rachel then displayed the lumber invoice. Front Range Specialty Lumber had paid nearly $18,000 for black walnut and red oak logs. The seller was HOA Community Consulting LLC, the company owned by Karen's brother. The money had been deposited into that company's account instead of the HOA treasury. The treasurer, Emily Carter, looked stunned. Residents immediately began talking over one another. Questions came from every direction. Where had the nature walk money gone? Why did HOA maps show Daniel's Pond as a community feature? Had the board actually approved any of this? Would insurance even cover intentional property damage? Karen tried to force the room into a vote anyway. Emily refused. Several other board members joined her. The emergency assessment collapsed. The project was officially suspended, and an independent legal review was ordered. As Daniel and Rachel walked toward the exit, Emily followed them into the parking lot and quietly handed Daniel a folded note. Inside was an address and a meeting time. The next morning, at a diner several miles away, Emily arrived carrying copies of contracts, altered meeting minutes, printed emails, and an external drive. The records revealed that the nature walk had been planned long before Karen ever brought machinery onto Daniel's property. His pond had been labeled an existing community water feature. His tree line was marked as future common space. His private road was listed as a construction entrance. Karen had planned the entire project as though the HOA already owned Daniel's land. The financial records were even worse. Of the nearly $180,000 collected from homeowners, Approximately $74,000 had been paid to HOA Community Consulting for vague services such as access coordination and land preparation. Emily had never seen any actual work product from the company. In several cases, official HOA minutes claimed unanimous approval even though the draft minutes showed that no vote had taken place at all. Then Rachel opened a spreadsheet stored on the drive. Its title was Mercer Acquisition Pressure. Inside were detailed plans covering complaint campaigns, reputation pressure, contractor access, boundary adjustments, emergency excavation, and completing the project before Daniel could challenge it legally. One line read, "Create enough visible investment that Mercer must negotiate." Another said, "Shift markers before equipment mobilization." At the bottom, beside Daniel's name, Karen had written, "If challenged, characterize as drainage, emergency, and owner obstruction." This was no longer a misunderstanding or a simple property dispute. It was a deliberate strategy. Rachel immediately issued preservation notices to every party involved. No emails, text messages, invoices, devices, or project records could be deleted, altered, or destroyed. The reaction was immediate. Contractors began blaming Karen. The survey subcontractor claimed it had only placed temporary rods where Brad instructed. The HOA attorney admitted he had never personally verified the deed or easement claims and had relied entirely on Karen's description. Board members began distancing themselves from Karen. Insurance carriers issued reservation of rights letters warning that coverage might not apply to intentional trespass, fraud, theft, personal profit, or destruction of evidence. Then another critical piece of evidence surfaced. A text message Karen had sent Brad 3 days before the excavation. "Shift the markers before Monday. Once excavation begins, Mercer won't be able to stop the project." Brad replied, "What if he has cameras?" Karen answered, "He won't see us at night." For the first time, Karen's position as HOA president was no longer protecting her. Instead, it was identifying exactly who everyone else intended to hold responsible. Then she made one more potentially disastrous decision. After receiving preservation notices from the HOA's new attorneys and its insurance carrier, Karen remembered an old HOA. The laptop was hidden inside a shed near Daniel's northern boundary. It contained early trail maps, contractor notes, and records proving that Karen had always known exactly where the real property line was. The board's attorneys planned to inspect the shed the following day. But that night, Karen and Brad returned to Daniel's property. Her old key no longer worked because Daniel had replaced the lock. Karen pushed Brad to cut through a smaller chain on the service entrance and then break the shed lock itself. He hesitated, but she reminded him that the files inside also proved he had moved the boundary markers. Neither of them noticed the infrared camera watching from above. Daniel received the alert, called the sheriff, and switched on the exterior floodlights. Karen rushed from the shed carrying several folders and an old gray laptop. She jumped into her SUV and tried to escape, but drove directly into the muddy ground created by the irrigation damage she had ordered weeks earlier. The vehicle sank almost immediately. Deputies arrived and searched the area. Inside the shed, they discovered records, the laptop, a portable shredder, and the missing survey rods. Brad asked for an attorney and then agreed to cooperate with investigators. 3 weeks later, mediation began with the HOA offering Daniel $45,000. Karen still believed the entire matter could be settled cheaply. Rachel calmly laid out the complete case. The arborist valuation, fake permit, relocated boundary markers, timber sale, altered meeting minutes, hidden payments, internal spreadsheet, signed trespass acknowledgement, and attempted destruction of evidence. When Karen asked whether the insurance policy would cover everything, one attorney explained that it might cover ordinary negligence, but likely would not protect against fraud, personal profit, intentional destruction, or deliberate concealment. Karen finally understood how serious the situation had become. "What was the original number?" she asked. $25,000, Rachel answered. "We can pay that." Rachel closed the binder. That offer expired months ago. The case then proceeded to trial. Witness after witness confirmed Daniel's version of events. Miguel established the true property boundary. A county official confirmed that the permit was fake. The landscaping foreman produced Karen's signed order authorizing the removal of the walnut. The excavator operator testified that Karen instructed him to cover the broken irrigation line. Brad admitted that he had moved the boundary markers in exchange for a $4,000 bonus and had helped Karen return to the shed. Emily explained the altered records and hidden payments. Dr. Samuel Reed brought a polished cross-section of the fallen walnut into the courtroom and pointed toward its growth rings. "The species can be replaced," he said. "The 46 years cannot." Those words stayed with the court. 2 weeks later, the judge entered a judgment exceeding $1 million. Liability was divided among Karen, the HOA, Brad, the contractors, the survey subcontractor, and HOA Community Consulting. But the portions connected to fraud, personal profit, intentional trespass, and evidence concealment followed Karen personally. She was permanently prohibited from entering Daniel's property. The HOA filed its own lawsuit seeking to recover the money that had been misused. Karen's brother shut down the consulting company, and the financial records were referred to prosecutors. Daniel did not attend the meeting where Karen was formally removed from her position. Instead, he stayed home with Samuel and the restoration crew. They repaired the damaged irrigation line, stabilized the slope, and planted new walnut, oak, cedar, and aspen trees. Daniel cleaned his father's old metal sign and mounted it on the new fence. The words remained, "Plant something you will never live long enough to sit beneath." Beneath them, Daniel added one final line, "Private property authority ends here." One evening, the security system sent another alert. Daniel opened the camera feed expecting trouble. There was no excavator, no clipboard, and no HOA truck. Only a deer moving quietly between the young trees. The $25,000 demand had never been revenge. It had been Karen Holloway's last cheap way